Okay, loved ones, continuing from the segment last night regarding Q&A. I'm not even sure what number we're on. So Knighton went on to say, we have found in numerous circumstances through vital statistics, they will not create a birth certificate without these two particular numbers. The numbers are from the informants. They're taking information, they're affixing a particular file number to it so that that information can be shot down the commercial exchange tube. That's all that's happening. Every event is going to circumstantially have some type of a number fixed to it as a property identifier. This is why we want to be filing or recording events. The birth event is an event. Again, yeah, baby comes into the world, but two events are actually created here. One birth, the man or woman as a child, that birth event, and then the birth of a corporation that's registered under Her Majesty's rules and regulations under all the legal stuff that they do, creates the second event. I'm of the opinion, again, I'm not the only one to say this, but I think this is legit. Every birth certificate out there, look at it. There's two birth dates on it. There's two entities and there's two birth dates, technically. You got the corporation, the day it was registered, that's its birthday. That's not your birthday. Your birthday is the day mom's water breaks and you go, skipping down the table. The two events. Event number two, the registration date, is that particular thing's birthday. As a matter of fact, buddy of mine and back home, when we were monkeying with this a few years ago, sends in another birth certificate application suggesting, hey, the date's wrong. And then they got back to him all right, like as in the Department of Justice got back to him. You better not be making fraudulent claims, and if you are, you could be subject to imprisonment and all this, yada, 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 yada. But what we're suggesting here is, hey, two events, two entities. Where's the third event and the third entity? That's the trust appearing that we manifest and create. That thing is also an event that's recordable. I don't want to say registerable, but you get what I'm saying. But don't get me wrong, the trustees take that security interest, they go register it as the new registered owner. They're totally entitled and empowered and actually instructed to go do that. Again, as I was saying yesterday, the registration process helps to pass titles and liabilities and debts and credits and all these things. This registration process, I know there's been a lot of talk about, every time you register it, it makes it the property of the queen, blah, 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 blah. You know what? That's kind of already happening anyway. So let the trustees go run with that idea. Let them be the owners. Let them have, the possession of this thing so that they can be responsible for it, not you. Again, remember, the 1933 scheme was to convert the collateral of countries around the world. They took bonds that used to be collateral for things, they switched that, or they subordinated it, and they replaced it with your labor is now the collateral to secure payment for instruments. This is why they took the gold and silver standard away from social citizens, because you use that tender, or you use that currency, or you use that monetary value to bring value to your expressions, your agreements. So if you don't bring value to an agreement because they took that away from you because you appeared in this document to be a social citizen, social citizen A, B, Johnny, C. This guy forfeited his right to use currency in specie, or actual consideration, real value. So when you take that real value and you attach it to the collateral, you can do stuff that replaces you and your labor. My back's sore, for being the fund that pays for all these public corporations and their governments and their debts. It's your labor. This is how they really, really wanted to ensnare the people and enslave the people and this, that, and the other. Dubious, as we all know. But again, they weren't able to put this through unless they had the back door or an open window somewhere that you could crawl in and out of, so that you weren't trapped. Because right out, slavery is technically abolished. But if you volunteer to be a slave, that changes things. So they created this whole thing to allow you to volunteer to be a slave. And then they got you. Okay, moving forward. From what I have been able to find, the legal marriage creates a bond, and this bond needs to be extinguished. What needs to be done in addition to the affidavit and certificate we create to do this? What else needs to be done? I'm going to suggest when you have the two parties that were originally parties to the legal marriage, when you have them coming forward and say, hey, we both consent to the parties. That's agreement. Once you have agreement, the judge can't say, well, I don't think so, right? No, again, the agreement between the parties is very powerful. Okay, so now you got Steve and Janice. They both show up. Hey, we want our marriage annulled. We want to dissolve this bond. We want to create a new one. So a simple deed, if you want to break this down if you want to get into rescission or just the term of this agreement has expired, even though you swear till death do you part, right? So that's literally suggesting, hey, you can't break this thing until one of you dies, then it's broken. Well, I'm suggesting through the doctrines of equity, we can literally make that entity die. We can sever, we can chop it up, we can rescind it, we can retract it, we can absolve it, we can void it, we can demand it, we can discharge it, we can do all kinds of things. Put that in your in a deed. I'm thinking again, a new deed of trust is going to take any other bond out there and swallow it. So that's kind of a voiding process. It kind of is a vesting process. It is sort of a, hey, there's a transfer that's happened. Title has passed. There's all kinds of things we can do again, because remember, none of us showed up at that marriage ceremony and the subsequent certificate that gets spit out from this event. None of us were acting in our duality. None of us were duly present. I duly promise to love you. No, see, I only promise to love you in person. Ha ha ha. If the ha 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 is good because you want to get out of a marriage, or if you both have the ha ha, there's the out. We wish to remove the personage from this event and create a new one, a cleaner version of it. What else do you want to do? Void, write void on the original marriage certificate. Both parties agree that this is void, because technically that's probably all they're doing in the background anyway. But the judges and the clerks, they'd be signing off on it and doing it for you. However, okay, so again, the affidavits from both parties saying, yeah, we wish to terminate this legal agreement because there's no equity in it. We want something better. We wish to reform it. Reform is a big word. This has ecclesiastical spins on it with the reformers, the Reformation movement. I can't remember the name of the guy that started it, but it was a big deal back in the day. And I think this was leaving the Church of England so that he could go start his own type of thing, minus all the serpent-like tentacles that's mixed into it here. What else do you want to do to dissolve the marriage? That's pretty much it. You know, again, just a declaration, a declaration and proclamation. We can do a couple of things here. And again, these don't need to be 30 pages long, loved ones. Just a few sentences describing the where, the why, the who, the when back then, the circumstances now, and what the expectation is when we're done here. So you probably pull all this off in like 8 sentences type of deal. And as long as you both sign it, and again, now take it and go have that notarized if you want. Again, just make sure that notary is acting in his private capacity, which encompasses your duality. If that notary, here's the explanation on it. If that notary is only acting in person, he's or she or is unable to recognize your duality. Again, when we got a mask on, we can't technically see anything real. We're not participating in anything real. It's all fraud. So if you have a notary acting in the fraud position, the at law, common law, legal side, that's all fraud. When you have a fraudulent witness bearing false witness, that's not good enough for what we're trying to do here. So make sure that this notary is acting properly, at least in his duality, so that the man, whoever this witness is, can sign off on it legally and equitably, the duality. Okay. I have often used the language rights, titles, and interests I see in the crayon sample rights and entitlements. My question is, do we want to use rights, titles, and interests as in no one has a superior claim to them? Yep. Right, title, and interest. These things kind of all work as a package. You can claim you have a right, but if you don't show an interest, as in doing something, where does the title come from? See, 1, 2, 3. If you don't do, hey, I've got a better title here. The judge is like, oh yeah, what right did you use to get that? Really? Show me the evidentiary chain of your interest. Where did your interest spring from? Shit, I don't know that one either. Right. So this, again, this is why we want to, manifest out this stuff, the ABCs and 1, 2, 3s. On this date, I did this. On this date, I did that. And then the result was this. And then my intent was to do such. Boom, 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 boom. Lay that out in like as best a chronological order as you can. Again, it doesn't need to be perfect. It just needs to be there. That's kind of reminiscent of the perfecting process. When you perfect our interests here under whether it's the Personal Property Security Act, that's the big one. What else? We got the Securities Transfer Act. You can probably perfect it under there a little bit as well. What I'm getting at is that in those bodies of legislation, they actually state it doesn't matter the order of perfection, because they're alluding to, hey, there's a couple of things you got to do here, at least minimum 2. And it doesn't matter in which order they appear, as long as they appear. So yeah, rights, titles, and interests. Another one is a right coupled with an interest. That means as in they're locked, can't separate them for any reason now, unless you choose to. Now, again, when you're going to use right, title, and interest, make sure you're talking about the equity one. Set that phrase up just prior, saying, hey, with respect to my equitable interest, or with respect to the quiet enjoyment of, or with respect to equitable ownership, however you want to spin it, as right, title, and interest, relating to such and such a property interest as relates further to a particular certificated security in registered form. It's good. It's always going to support what you're doing. Now, again, we don't need to get too carried away with that. Again, as I'm suggesting here, ladies and gentlemen, once we have the written agreement from you going to the Attorney General's office privately, ex rel. That's in my relation capacity, not the it capacity. As soon as you express a relation, then the whole game changes. We've struggled with how do you express the relationship properly? Well, you got to declare it, for starters. I would do it in writing, for starters. Have it wrapped up with a new something that's going to take your place, so that there's not a skip in the system. You checked out, but checked something in. It's like that quick little swap, Indiana Jones style. This is going to have the system stay online. It's not going to cause a lot of confusion, a lot of chaos, things of this nature. So yeah, right, title, and interest, it is an important phrase. We do use it a lot. But again, as long as you convey that right, title, and interest to the Attorney General properly, and as a result, you're left with, or in remainder, you have the equitable interest for your quiet enjoyment, your beneficial use. I'm still going to suggest we be careful with the word use. As I've suggested back in the past, there's something going on with statutes of Victoria or Elizabeth or one of these ladies from back way in the day. Legislation distinguishing a slight difference between the word use and the word trust. Yeah, they're kind of intermingled, yes, of course, but if you use the word use in the wrong context, you're kind of literally putting one foot back into the legal system. And again, this is why I'm suggesting that there are so many snares that are going to face us every day for the rest of our lives. This is why I'm suggesting, loved ones, we just really want to get rid of this whole trustee position. Just give it to a department that's capable of dealing with our securities, believed capable. Then that way we're never really going to have to worry about making a mistake, because I don't want to feel like we're being haunted with, oh, I have to be super careful with everything I do and say. I can't write down something that's not perfect, otherwise it's going to explode in my face. give it to the AG. Here, you get the legal right, title, and interest, an undivided legal title, right, and interest as it relates to blah, blah, blah certificate. Again, show up as the relator. Ex-rel and relator are going to be two new terms that we're using a lot. I mean, I know others have touched on in the past, but it just kind of never really flourished into how important it really is. But those two words being used together in conjunction sets the stage for you to engage the Attorney General to act for the trust, not you, the trust, properly. And yeah, Carol was correct. Yeah, no one has a superior interest to these things. Once you transfer them and once you displace them, once you dispose of them, they're locked down. No one can have a superior interest now because it's set. And once the concrete's set, you can't go write your name in it. Punctuation versus intent. Intent is what matters, correct? Yeah, absolutely. Intent is everything. I'm going to suggest, yes, you could, in a crayon, write in one continuous sentence with no punctuation. Is that still capable of transmitting an idea, some intent, things of this nature? Yeah, of course. Am I suggesting we go do this in crayon? Well, no. We want our documents to be, clean. It's designed to go into a vault so that it can be looked at again, 250 years from now type of deal. I know they're going to microfiche this and put it on digital formats as well. Yeah, I know. But I mean, if it really turns your crank that you have to do yours in crayon just to prove a point, yeah, giver. I'm just suggesting, just as long as it's legible, as long as you're pretty sure that that crayon does not rub off, which it shouldn't. Yeah, you're technically intent is fulfilled here, and not punctuation or styling or how you pen to paper it, really. Okay, so yeah, that went on to say, it is suggested to have your birth certificate authenticated before surrendering. You know what, Dean and I did the whole authenticating thing. The only thing that they will authenticate is the larger live birth records. And really, what this is doing is only the owner can authenticate the owner's certificate. So if you really want to doubly prove that this thing that's already a photocopy, again, that's the only reason you're going to want to get this thing authenticated, because it gets spit out from the vital people as a copy. It's an extract of the original. So it might be printed on original paper, but the information on it is still a copy. It's technically not an original. Going and having it duly authenticated at the provincial and federal level. Okay, well, what was that trying to do? Well, that's trying to encompass, hey, we're just trying to get as many jurisdictions on the table here so that they can be accountable later. That's really all we're trying to set the stage to do. I'm going to suggest this isn't a requirement. Now, I know I'm going to have a lot of flack out there about people saying, yeah, it is, yeah, it is, yeah, it is. But again, remember, at the end of the day, loved ones, this process was supposed to be simple. Every time we want to introduce a whole other layer or a whole other process, look at it. Okay, is it reasonable? Is it reasonable that a simple man carrying around his normal birth certificate, okay, like the ones we have in our pockets all day, that one is an original, different. So we have this original thing that we can go conduct commercial activity with, correct? Yes, we've all done it. Is it reasonable now that that's not good enough for some reason? And now we got to go back to the mother document, and that's a copy. So now we got to go get this copy duly authenticated and stamps all over it, and this whole process just to make it commercially viable so that we can transfer it back to the trustee from which it came. If they're not going to accept their own certificate, then we got a problem. And again, this is going to come into what's reasonable. Is it, Your Honor, it's not reasonable that I have to go do all this extra shit. Sorry, it's just not. When I have something here that is fully evidencing everything that's attached to that other one. So what the hell do I got to play around with the other one for, technically? It's in their vault because it's the master document or one of a series of master documents. Let them have those. I'm of the opinion that we don't need to chase that shit. We just don't. Simple. Let's keep this simple. Is our process going to be fatal if we don't duly authenticate? No, not at all. Because I've already seen firsthand knowledge and experience of things happening with just the little birth certificate, the spit out version of the mother. We can use this little offspring instrument to go affect everything that we want to do. So I'm going to suggest no, just surrender it. And by surrendering it, that word means that we're not going to negotiate it. We're not going to act in person for this thing at all. This is the whole concept of what surrendering it means. It's a peaceful method of putting possession into the hands of another party by surrendering it. It says that single word alone accomplishes a lot of stuff. Darren, do we have to surrender it? And I'm going to say no. You can just assign it absolutely to the new trustee. That gets it done too. But you know what? If you're in a situation where, let's say, the sheriff is on their way to come arrest your ass, what are you going to say when the sheriff arrives? Don't arrest me. Wrong. He presumes that you're acting in person. Off to jail you go. If you say, whoa, I surrender the legal interest attached to this certificated security, which I've collateralized, I've made it better with some value, and I'm putting it into your possession. This is where the whole sheriff's thing came into the equation back in the day when we were talking about, hey, to avoid the HIV going in your arm, apparently, this is the newest thing. In order to stop that little series of events, we were in scramble mode. What are the most effective things we can write on a birth certificate to stop the knock on my door? Give it 5 seconds. Oh, boom, look, they just kicked the door right in. And they're all dressed in white suits and they've all got they're here to stick me with something. That's what that emergency type application of the surrender was originally designed to do. Okay, the live birth registry, LBR, creates the birth certificate one before the other. What prevents the BC birth certificate from being used in bearer bond fashion? Sorry. If we simply declare we have an equitable interest in the birth certificate without need to show identification, LBR, then what is to stop others from claiming equitable interests in more than one security? BC, can you go grab me off the top shelf the folder, like right now? Yep, in the closet. Just one moment. Again, see, this is a problem where I don't read any of these questions preemptively, or else I would have had this ready to go. But just bear with me for a second, because I gotta. Here's part of the answer to this question. Okay, what's the difference between in bearer form and in registered form? When you make a certificate payable in bearer form, you're suggesting, okay, whoever holds this certificate in, okay, see, that's the thing. That certificate literally transferred hands. It went from whoever had it in possession to now they've done something to it and they've made it payable to a different party. Okay. In bearer form, just so that, because I know some of you are like, oh my God, I want to be able to read that. What does that say? So here, this is all going to get posted later, but you know what? Here, I'm just going to just do this for you, just so you have a quick little tickler. Okay, now I'm going to turn this sideways. This is what that little red writing right up here is starting to say. So we got a British Columbia birth certificate here. We're titling this thing instantly as a financial asset, right off the hop, direct holdings. Birth certificate, right? That's their word right there, birth certificate. Birth certificate made payable to bearer, semicolon, namely RBC Royal Bank, pursuant to the Securities Transfer Act, section whatever, 23, let's say. Put your squigglature right on it above their squigglature. You know what you just did? The bank knows what they can do with this. And what it's all about, well, this is ratified in trust. This is what I got written down underneath the signatures there. Ratified in trust. That sounds pretty delicious. And you know what? Do a little bit of digging, because it is pretty delicious. Put a date on it. And then down here, also we got, just on the side margin, special deposit. And this is, again, this is on the backside of the rest of this. So I'm just going to do this quick so that you can at your leisure go pull through this, but I don't want to make it too publicly available right now. So there you go. Payable to bearer. Yes, Knighton, fantastic question. That's exactly what we're doing. When you're in possession of this thing, you have the ability to do stuff with it. This is the thing, loved ones. Technically, okay, I'm going to boil this one down. Technically, we never ever imparted with our equitable interests, our equitable titles, things of this nature. We kind of have just not got the ability to use it anymore because we forfeited it when we showed no interest in it. Sneaky bastards in the background said, hey, if you don't express an interest within your certificate here, within the first 7 years, here's a warning. So 14 years, here's another warning. And by the time you got 21 years under your belt, you've gotten 3 warnings that said, hey, you've shown no interest in this thing. Now it's absolutely deemed to be abandoned because of your neglect. That's the word they use, your neglect. Your neglect has caused your equitable interest to be forfeited. So now someone else can quietly enjoy your labor because this is what you've chosen to do. How do we defeat the forfeiture? Well, that's easy. Equity abhors them. There. And now I'm intending to do equity. That's why I'm seeking equity. And here, look at my clean hands. These 3 doctrines, these 3 maxims, spin them together. They're pretty powerful. Made payable to bearer. You took the collateral and attached an interest to it by writing it right on it. There. That interest cannot be removed now, right? Like it's set. It's cured. Once this thing is made payable to bearer, that's meaning whatever you had, you're granting it or donating it. I don't like donating it because it implies that you don't want something in return. Although you'll see, once you do a little bit of digging in this, they use the word donor a lot. Donor and donee. Just make sure that you, if you're going to go that route, just make sure you specify, hey, this donation is not a gift. Because as soon as you gift it away, now you can't say you owe me. See, you just waived that. So again, we got to be a little bit careful with donor. I'm not saying don't use it, just use it properly. So yeah, use this thing in bearer form so that when the bank gets it, they're like, aha, look, this blank check, this negotiable instrument under the Securities Exchange Act stuff, they've made it payable. They've made it payable to us. So now they can take this thing because you endorsed it. This is the real deal. Now they can take this thing and go down to the land department and they can register their interests in what you just created. That's an agreement. They can go now register their interest in the agreement securing the transaction. They get registered as the legal owner of this. And whatever that paperwork was spun around this birth certificate, I don't know, maybe to set up that account for set-off we were talking about. They can't create the set-off account until a special deposit opens that account. What was the special deposit? Well, we got a certificate made payable to bearer. That's an upgrade. Here's the other thing. When it's made payable to bearer, re-registering the thing is kind of implied. They actually don't even really have to go re-register the instrument, although they're encouraged to, just to protect all the parties here. Because it was registered and issued once, when you do this, loved ones, okay, it was issued to you. Now you are issuing it to someone else. This is called in issue. You can't claim to have an issue if you don't provide some type of proof that something's in issue. Your Honor, I have an issue with the officer giving me a speeding ticket. I was only 4 kilometers over the limit. If you don't raise the issue by actually transferring the issue, by reissuing a particular certificate of security and registered form now made payable to bearer, namely the state, a bank, a trust corporation, your trust, this is how we fund stuff. This is how we tap the Treasury accounts without filling out the Treasury forms. See the difference here? I don't want to play trustee. I want to let the bank play trustee. And in this document, we're actually suggesting, hey, The bank now becomes the attorney. We're giving them power of attorney. They have power to act as attorney for the trust as it relates to this particular matter. They're literally attorneys in fact. They can take this instrument and this collateral and this stuff, and they can go do stuff. Now they can open up the set-off account because they're not interested in what funds the set-off account. Your labor? What if you fall off a ladder tomorrow and you break your leg? Well, your labor sucks now. This is why you had to get insurance. In case you fall off the ladder and do more than break your leg, insurance now kicks in to make the payments. Well, we can avoid that whole scheme by directing the holdings of these particular bonds and put them into the possession and the capacities, how they were supposed to be done. See how you go right around the labor portion? Again, the certificate is the collateral. The certificate represents the consolidated revenue fund and your specific or particular chunk or portion of it. Every country is going to have a consolidated revenue fund because every country is operating in debt because we all volunteered to that's what we wanted to do. And they're like, well, okay, if you want to abandon all your legal interest, or sorry, all your equitable interests, we'll create a legal scheme for you all to play within. That's all that's technically happening here. So yeah, this is exactly what we're doing right here. Make it payable to bearer. Put some value on it. Put some intent on it. Put some direction on it. Identify who the receiver or the recipient of this particular little exchange is going to be. And you can pull this off as long as you show up in your duality. Duly execute, duly endorse, duly deliver, duly. As long as you're doing that, they can't sting you with, you were only acting in person. And persons are crazy. And persons don't know what the fuck they're doing. They need to be babysat. That's why they're deemed wards of the state. Until you've been rewarded for your discovery, you're deemed a ward. Your Honor, I have an equitable interest in this birth certificate. Do John Billy. I am John Billy, the settler, protected, purchaser, hire. Meanwhile, the one claiming an equitable interest is Anakin Skywalker. Yeah, I'm gonna see if we can decipher this one a little bit. Okay, so we have a party telling the judge he's got an equitable interest in the certificate. So the certificate is present and the holder of it. Okay, so that's one party holding the legal interest. This is the all caps, you showing up as an agent. And again, you can play on the word agent a little bit. Agent without recourse. So what the word recourse is suggesting is, okay, you've heard of in due course, and now we got recourse. And do you know what? Of course, that's another one. Of course means when we're doing the legal system and spinning all this admiralty stuff into it, they have a specific course of action that is likely or deemed they will follow this course. So this birth certificate was issued in course. We received it. We used it to create another course of action when we identified as the thing and then assumed all the liability, et cetera, et cetera. That's one course of action. So now we're showing up and saying, hey, I'm directing it. Honey, I need my charger. We are setting up a whole other course of action now. This new course is without recourse. This course we're laying down right now cannot be undone. It can't be changed. It can't be redirected. That's why we're saying without recourse. So I'm an agent for the principal, which means I can act on behalf of this thing. I'm entitled to do that. And without recourse means that no one can monkey with anything I'm trying to do here moving forward. So yes. Okay, so really, this is going to start to fundamentally break down into, okay, who's expressing what interest? Is it you expressing an interest in the security, or is it the trust expressing some type of interest in the security and you're just a quiet beneficiary in the background? I'm going to suggest it's the trust. The trust you create is the owner of the equitable interest. So that's a thing. You just show up and enjoy the thing. Let the thing do all the owning. Let the thing do all the directing. Let the thing act. It's its own entity. This thing is now in the possession of the Attorney General under a private appointment. He's now going to act, she's now going to act to protect the interests of the trusts, its settlers and its beneficiaries, and literally the trustees as well. This whole thing starts to benefit everybody. This is why, again, I keep suggesting we always want to be calling ourselves the beneficiary. Okay, well, yeah, that's fine and dandy. But you know what? I would just like to break this down. And you know what? There's a direct beneficiary and there's an indirect beneficiary. The public indirectly benefits from this thing as well. So this is getting a little bit deeper into the scheme of things that we're trying to lay out here, but just keep that in mind. That's just something that, you know, what's the purpose of doing all this trust stuff, Darren? Well, ultimately, Your Honor, it is going to benefit the public. Oh. And what's your specific interest in it? Well, I was the settler. I was the one that created the whole thing. I became aware of it on such and such a date. And under the Limitations Act, that's when the ball starts rolling, technically. There's that period of point in time that we now start to measure. Because if for some reason, somebody out in internet land here got a copy of my birth certificate, scanned it, copied my signature, expressed an interest in my particular estate, trust, and are now trying to direct payment to a specific bank that they're trying to set up somewhere in the Caribbean. They're literally trying to siphon off my estate. It's going to be up to me now to say, hey, whoa, wait a minute, Your Honor, I didn't disclose any authority to a third party to act on my behalf, unless it was divergence. I didn't authorize someone in the Caribbean to liquefy my estate without my complete written consent and permission. No. So this is where the trust is going to be the one that manages this whole thing. Now you got managers of the trust. This is what the receivers and the managers are doing. They're actually dealing with all of this stuff for us. When loved one gets equity using the 30% only and are part of the garden, are they able to still help humanity with their abundance? Obviously, people have obtained it over the years, and I'm just wondering, because many of us have found the Dï5 because we have been looking for the answers to remove the shackles completely. And many followed your brother back in the day. Since I found Dï5, I see the bigger picture and the world versus me, or versus a me way of thinking. Just like Dean, Darren, and others have been teaching the truth, I feel perhaps even peeps that aren't gardeners can still be helpful in some way with boots on the ground. Thanks in advance for addressing this big question. Okay, Carol, yeah, that's a good one. Again, we need to just take a step back now and look at, okay, what is Darren trying to I don't want to use the word personally, but you all try to understand what this means. What is Darren personally trying to do here? Well, I'm trying to suggest that we need a layer of people that really know what the hell is going on, that can literally step in, fill the shoes, because there's going to be a big void here right away of people that are trustworthy, that can command things like, among others, angels, command the militaries, help revamp the banking system, help bring in positive change to the world so that we defeat homelessness and all the other bad things. So Carol's suggesting here, okay, so if we're only using the 30%, we're still technically part of the garden. Yeah, of course. So let's say, what is the 30% going to do? Is the 30% going to get you into this layer where you're helping on the bigger picture like Darren's talking about, or is it just going to get you your 30%? Oh, this is where the Nasera Jacera drip is going to be. Your 30%. Yeah, you proved an equitable interest. You set up a trust. And let's just say, okay, you're no longer getting speeding tickets. Maybe you even have a set-off account. Good. Are you able to go and affect positive change throughout the world? Yeah, absolutely. Are you going to be able to do it at the level I want to do it at? Probably not. You're going to run into some more hurdles. This is why I'm suggesting having the Attorney General technically being your personal representative. That's probably how this is going to boil out. The commissioner they appoint to manage your trust is going to be fluent in the legal system. Where does this fluence come from? Well, it's probably going to be a lawyer or a solicitor of some type that knows what the hell's going on. This lawyer, directly appointed by the Attorney General, is going to manage your stuff. Hey, Susie, I want a school built here. Susie says, yeah, but Darren, you've only set up your process here to cover $1 million at a time. So we're unless you want to build a school that's under $1 million, we don't really have the authority to put together a larger school for you. So this is why I'm suggesting just the drip in Sarah. You're going to get a check every month for, what is it? I don't know, let's just say 5 or 10 grand, whatever it is you do and how big your family is and, you know, all the requirements of your household. Yeah, and really technically what your vibration is. Yeah, you're still technically in the garden, of course, because you know you're not acting in person no more. You've accomplished some stuff. But are you going to be, you could still be an asshole though, that's the problem. Because again, getting the 30%, this is just a matter of filling out a few forms or plunking your name in a few places and having some intent and knowing what to write on a birth certificate. A complete asshole can do this. Yes. Now that complete asshole, is he or she going to go and do magical, beautiful things for healing and spiritual revelations throughout the planet? Probably not. Assholes don't typically work and operate like that. What I'm suggesting is I want to make sure you're not an asshole. I want you to become part of this team. Jump on this train, help us clean the oceans, help us put new governments in place, help us capitally fund entire countries that have gone bankrupt, literally have the ability to step in and take over a country if you don't want to just go start your own. That type of personality, that type of soul requires a little bit more substance. Again, this is going to require the 70% we're talking about. This is going to talk about spiritual harmony. This is going to talk about all the other stuff that we're doing as the appetizer to the main course. If you show up at the table and you paid $100 to sit down and eat, are you going to eat the appetizer, then jump up and run away from the table? Or do you want to appreciate and experience what the meal was, what the dessert was, maybe the wine after the fact? Again, more layers. If you're happy with the appetizer, fine. Just do the 30%, go. I'm just trusting that you're not going to be an asshole with it. And by me saying I'm trusting, I'm invoking them. We're hoping, trusting that you're not going to just run off and be an asshole with all this stuff. Yeah, okay, so Carol's talked about here. Yeah, again, the intent, Dean and I and many other loved ones, that's all that we're trying to do is elevate the consciousness of mankind through information, awareness, truth, and knowledge. Put that into your spiritual basket. That's going to elevate you. So this is why I'm suggesting the 70% is more important at the end of the day than the 30. It just is. Because when you're standing at the gate, the proverbial gate, and they're going to say, whether they're going to let you in or not. Okay, yeah, you transferred a security interest in a birth certificate, but then look what you did after that. That's where we're going to be judged. And this is where we want to make sure we're not working iniquities. Even though you might be a little bit more powerful. Now you got $10,000 a month showing up. Yeah, of course you can go affect world change with that. If you so choose to. All I'm suggesting is that Jacob's ladder, it had more than 2 rungs on it. Okay. Is there a way for me to identify if my paperwork is too simple or a crayon level? Here's how you can identify. Take that birth certificate, tell the judge or the sheriff or the cop, this isn't me. I'm the relator of it or to it. Really? What's your relationship to it? Well, I know I'm not the debtor. You just accomplished a whole bunch by saying that. You literally imply you're either the settlor or the beneficiary by suggesting you're not the debtor. Who is the principal debtor? Well, it's probably the state that created the thing. They're the principal debtor. Imagine that. You show up and say, no, principal debtor, I volunteer to be principally liable for this thing. Principal debtor sits down and says, well, okay, if you want to, sure, we'll let you do it. You run off with it. Spend the rest of your life under the guise of a mortgage. 1933, this was a big mortgage. That's what happened. We now become the debtors, the liable party to a mortgage on the common law side. This is why equity abhors the forfeiture and allows us to reverse this mortgage. You ever heard of again, for real estate people out there, a reverse equity mortgage home loan? They're taking equity that you've built up and they're creating another mortgage on it and getting you to pay for it through the value that's already been established here as kind of a collateral type idea. Well, imagine if we spin this concept around the birth certificate and not a house. A reverse birth certificate beneficial ownership mortgage in equity as declared. Again, you just kind of come up with these things. And if you really want to write on your birth certificate in crayon, no one's going to stop you. But I'm just saying, make sure it's legible. Make sure you get a number of things put on here, as in who are the parties, what's the intent, under what code or statute or doctrine are you doing this, how you affected the transfer, and where's the value. And maybe does this thing have a termination date? Let me throw that on there too. You've just met like 5 elements that it takes to create a trust, or at least a bona fide contract. And again, I don't like the word contract anymore. What should be the process for us best to choose and name a trustee? You know what? Any government official, just not the judges, is technically in a capacity where they've sworn an oath to serve Her Majesty the Queen in the right of whatever province they're in, or the state, serving the state. Those volunteers have already signed and made an oath. They've sworn an oath to be liable to being appointed duly a trustee. Any of these cats will do. For us lately, I just happened to pick the Minister of Finance. I don't have any particular information on this woman other than her name and her service address. You can literally write that down. Minister of Finance in whatever province you're in, and care of station XYZ 123 province government, whatever their address is. Here's the cool thing. Equity will allow your entire process and procedure to go through without the trustees technically given notice. The trustees actually don't even have to be given notice that you're doing this. Yeah, they eventually get the notice because they have to act and get on it. But to get the ball rolling, you can do all of this stuff without notice. That means you're without notice that there's a prior or a superior or an equal claim to what you're about to do. And you also don't have to give notice to the trustees. Why do we not have to give notice to the trustees? Well, because no trust can fail for want of trustee. That means there's always going to be a trustee out there to do what it is you intend to do. So technically, do we have to appoint one right now? I'm going to say, yeah. Appoint the Attorney General's office duly as the trustee, administrator, and or executor. Other than that, again, leave the judges out of it. Appoint the Minister of Finance. Same thing. Appoint a government official. I'm suggesting don't go appoint your neighbor who has no idea about this stuff. How is he going to manage your trust? When all the guy can do is come over here and steal my lawnmower. I do not trust him with any other transaction. So appoint someone who actually knows what the hell they're doing. And if you don't know, you put it in there, do a little disclaimer or a waiver. Your Honor, to the best of my belief, knowledge, and that I assert the following, and I duly appoint the Minister of Finance to be the one. And if that is not in keeping with satisfaction and good satisfaction in accord with court rules, then may I suggest and motion that the court appoints the receiver manager, the trustee. You could put Mickey Mouse there if you really wanted to, and the judge will just reform it. Did you really intend to, appoint Mickey Mouse as your trustee? Well, no, Your Honor, but I don't know who it should be, so I figured I had to put a name down there. When one gets to the point in their discovery that it is clear what needs to be done with the birth certificate and why, would it not be best to go ahead with that phase 1 of the process, to have the separation of dead fiction from living man or woman, get rid of the possession, and then be the protected purchaser? Or would not completing all the process of assigning the new trustee, etc., leave us in a situation of incompleteness, and that would be considered laches? And after what amount of time? Yeah, okay, I think I touched on this one. I think this is a repeat question. for tonight's event, but I'll just got to touch on it again, seeing as we're here. When we create our trust, we got to do it within the scope of the Limitations Act, because the Limitations Act is what sets the timer. Boom. Once the timer starts, now the clock is rolling. Now the parties involved in this thing better start doing what they're supposed to be doing, because if you suffer a loss as the settlor or the potential beneficiary because the trustees didn't do what they did to do or what they were meant to do, if they were slumbering on the trust's rights, if they didn't act in good faith, if enough time goes by, that's going to start to harm or injure you and the trust. So therefore, it's important that we have the clock actually start working. This is why we got to kind of pepper our documents in the beginning with dates. The date that the trust was created may not necessarily be the date that the settlor or the beneficiary became aware of the trust. Or again, remember, Darren became aware of this whole trust shit 5 years ago, but it's still taken Darren up until now to fully express these things properly. Your Honor, do latches apply? Well, not really, because I didn't really set it up under the Limitations Act back then. So technically, maybe Darren's trust only really came online the moment he brought it under the scope of the Limitations Act. That's when this thing technically starts. And when a notary stamps it from their proper capacity, the private side, that's a lot of bona fide proof to prove or to establish that now we have a measurable event that we can sequence a chain of evidentiary proceedings from. The thing has to start somewhere. So again, protected purchaser, yeah, as soon as you affix a coin or consideration to that chattel, to that collateral, boom, you qualify as the protected purchaser. I've actually used that to a cop in the past, and they kind of looked at me sideways like they don't know what protected purchaser is or what it is. But again, I do have firsthand account where back in the day, I presented a birth certificate not as identification, but more or less as a bond that would take care of any wrongdoing if I was found guilty of wrongdoing. As the case was, the only wrongdoing we did is we didn't present a driver's license, registration, or insurance for the truck we were operating, manipulating. So because we didn't admit to being the liable party, but we were kind of suggesting, hey, we're implying this piece of paper, plastic, it's the liable party, officer, to whatever instrument you wish to draft. Perhaps maybe even in breach of trust, just because the officer doesn't know this thing's held or protected in a trust, they get a little sketchy. They don't want to trespass here because that's going to be a bond hit for them. And they know that. So you'll see them on the YouTube videos and things and the TikTok little videos about the exchanges going back and forth nowadays between police officers and people on the side of the road. What I'm suggesting, loved ones, is let's put the Attorney General, let's put the boss on notice of such and such an event has taken place and has been duly created, put together, endorsed, executed, delivered, that all the dualities present. And as such, word's going to trickle down through the police officer so that when he punches in your name into the system, there's going to be a, uh-oh, leave this one alone. So you'll be able to avert or subvert or not even really be in the position where you are going to get pulled over a lot because things have happened in the background. And I know just through simple correspondences, again, my one friend here who had his driver's abstract erased, that was through a letter sent to the Attorney General's office. And I'll be honest with you, it was a shitty letter compared to the stuff I'm writing nowadays. That was, I don't know, 2-3 years ago-ish, maybe 2. We've made a lot of progress with the substance and the particulars and the framing of our correspondences. If it's enough to get your driver's abstract wiped, then certainly things are going on in the background for that friend. So yeah, we complete the process of assignment when we absolutely assign it to the new trustees. Now, careful with the word absolute assignment. This is why. If you absolutely assign it to just this trust without naming other beneficiaries, that's a conflict. So we might want to just assign this thing, because I don't have absolute, I have absolute kind of control or use or enjoyment of this thing during my lifetime. I can actually assign other beneficiaries or appoint them to this trust. So what happens when I die? Does the whole trust collapse and all the beneficiaries are screwed? Nobody gets anything anymore? No, this thing continues. Because if it was absolutely assigned over here, that means it absolutely cannot be undone. And unless I make a provision in my paperwork that this thing continues, don't do the absolute assignment. See, I'll explain that one a little bit more. I could probably do another bit of a 20-minute or breakup on that one. But see where I'm kind of going with that one? Absolutely locks it down forever. It can't be changed. It's kind of like the irrevocable thing. So we just got to be a little bit mindful with some of these words that we're attaching to some of our intent. Because sometimes, oh shit, Your Honor, I didn't intend to do that. I didn't know the result of an absolute assignment meant I couldn't change it, or that the thing wouldn't continue on after I died. You got to be able to share it. Well, that shared interest needs to be defined a little bit in the paperwork. Once one files a financing statement at the Personal Property Security Registry and a schedule of goods, including the original security, the chattel paper, and other such serial numbers, does this change things in the public system? And how exactly do those numbers, securities, etc., become the property of the trust? And are they exempt from legal? Would I still be would I still be ticketed without a license? Will the car be towed, etc.? Here's kind of how it works. I created a trust over here although it's half full or half empty, whatever you want to call it. This thing has the capacity to receive property interests. We got a little space here. Here's a car, here's a house, here's a boat, here's a helicopter, here's a trust deed to build a hospital for sick children. All goes into your trust expression. The moment you declare property, this little thing, I declare this little piece of personal property to be ABC 123. And for the intent and special purposes of special deposit, I hereby declare that this property is now trust property. No one now has the capacity to go in and remove that. That's done. Even the Attorney General can't go say, no, settlor, you don't want to deposit that personal property into the trust you created. No, trust me, they don't do that. That's not how this works. Anything and everything can go into the trust. So what I'm suggesting here, loved ones, is, I know we've made some comments in the past about don't be worrying about your RRSPs and your crypto and the cash in your bank and da. Once this trust is set up and you create set-off accounts and you have direct access to Treasury through your trust, not you, your trust has direct access to Treasury, not you. For all those out there trying to fill out their 1099s and those forms, trying to access their trusts, I'm going to suggest you got to do that with a little bit of carefulness. Make sure you know who the players are. Make sure you know who these parties to this agreement are and set that up properly. You literally got to be entitled to access Treasury, which is oddly enough why when you appoint the bank to act as securities intermediaries, hey, you're now duly appointed to be in direct possession of this chattel certificated security in bearer form with value attached for the purposes of setting up an account, specially by special deposit for set off and beneficial use and enjoyment and by the beneficiary. All that property, your RRSPs, don't worry about that. Because when you drop your collateral into that special account, trust me, it's enough, if you so deem it to be, to make your RRSPs look this big. But here's the thing, loved ones. Every chunk of property that's registered in that name already, every RRSP, every insurance plan, everything that number and or signature is a party to, gets rolled into your whole grandiose trust that you're expressing in the background here. And again, this is why the Attorney General's office and the Minister of Finance, they got clerks and assistants and men and women coming out the yin yang to do all of this sequestering and marshaling and segregating and tracing Everything gets wrapped in here. Let the trustees do their stuff. If you want to, in your initial written agreement that you're sending to the Attorney General, right in there, you can suggest, oh, and by the way, the trust is in possession of the following personal property. Name them. And again, you don't need to get carried away and come up with a 100-page document here. But if you want to, go ahead. If that makes you feel protected because you've listed your refrigerator, the microwave, the TV, if that's going to float your boat, go ahead. That doesn't make your process fatal. Will you be ticketed and because you don't have a license? Yeah, no. Once you have a bond in place to cover any debt, loss, fees, costs, things of this nature, you are no longer liable through your own back in your labor to pay for any harm or wrongdoing caused by an accident. Again, you swoop in from your lane and you take out a family because you were texting. Yeah, okay, we all know we shouldn't be texting. And your negligence has just now caused the death of an entire family. I don't think it's fair that that family now only gets a check from the insurance company for $5.8 million. I don't think that's fair at all. I actually think that's insulting. So I would rather pay that family out $580 million. If I had the chance. I feel terrible. So bad now, like this event has dramatically changed the course of my life. And I can't do enough to now compensate that family for their loss that they experienced. So when you have this bond is now in the vault of a secured party, again, the bank becomes the secured party, not you. You indirectly are secured, yeah, because you have the beneficial use and enjoyment of all this stuff, sure. But you know what? It's the bank. They're the secured party. Why? Because they're sitting on the security. They have possession. They got it. Security and secured party kind of go together. Who's got the security? Whoever's got the security is technically the secured party. We get the beneficial enjoyment of a secured party, engaged in a particular collateralized security agreement. So yeah, everything now becomes property of the trust. You just got to declare it. You can do this verbally on the fly, yeah, sure. But if it involves land and property transfers, do them in writing. This is easier. Less mistakes, less confusion, less chances of things going sideways later. Because unless you actually said you're in writing or your viva voce, here on this such and such a date, I want to do this, blah, 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 blah. If you don't record it and someone questions you a year and a half later, okay, what did you say exactly back there on February 8th at 12:11 p.m.? I'll be like, oh, shit. I don't really remember. I have a tough time remembering what the hell I did yesterday. Put it in writing. When one serves private administrative process via registered mail and affidavits go unrebutted, where does one file such a claim, especially when it deals with things like Canada being a service corporation registered with the registration number as well as see again, see how there's just a boatload of where do we send and to who and see there's just this thing keeps unfolding. This is where, again, I'm going to suggest loved ones that were already dancing with the trustee here. Put this thing into the possession of the Attorney General's office, either directly or indirectly through the Deputy Attorney General's office. Do this once to the best of our ability. If they have questions, trust me, they're going to ask you. You can literally at this point say, hey, you know what? Please send the questions respecting the trust privately to this email address. I don't want to conduct business on the phone. Why? Because it's not secure. These are all public. Everything's public. I would prefer, as private as we can make it, Attorney General, send a secured communique to this settlor at such and such a Gmail address, so that this way we're doing everything in writing. Everything's tickety-boo. Oh, Darren, they're not going to want to do that. They're just going to want to try to intimidate you and make you drop the ball and this, that, and the other. Yeah, no, not really. And again, we can attest to this just in the last year through the process that we're doing with Jody and Kim's claim, that we were directly corresponding with the Attorney General's office. And you know what? Over the 10 correspondences we had back and forth, they're not out to deceive. They're not out to fuck around and play games. They're not out to cause strife. They're not out to do any of that bad stuff. They are more honorable than we think. Again, we're the ones that put ourselves in dishonor, not them. Yeah, I know they're acting in person too, a type of dishonor. But what I'm suggesting is we are the ones that identified as this thing. We created a whole circumstantial set of events that now when the hammer starts dropping on us, because we were warned through scripture not to do this, but our ministers, pastors, preachers don't talk about this shit on Sunday. Why? Because none of them know anything of this. They don't know any of this stuff. They ought to. But again, they went to, I don't even know what you call it. They went to preschool somewhere in Idaho. And now they have this little certificate saying that they're a priest. All that means is that they've read the Bible a whole bunch. And they can instantly refer to a particular verse and apply it to a situation here. Well, you know what? I'm going to suggest that they fail miserably in this regard. They have no common law experience. They have no commercial experience. They have no real experience with how scripture ties into those two realms. This is where all the priests, ministers, pastors, etc., fail us every Sunday. Yes, they're trying to bring us elated emotions and spirituality and help connect us with the above and all around. But they don't know anything about the personship. They don't know anything about legalese. They don't know anything about codes and statutes and corporations and this, that, and the other. So stop seeking advice from those who don't have very much. If going to church makes you feel fantastic on Sunday, you get a little bit spiffed up and you get to talk to Jane and Karen and all the other ladies. That's a social engagement that's beneficial for you. Yeah, go ahead and do it. All I'm suggesting is here, you're not going to find the salvation you're seeking in that building. It's not happening. So all I'm suggesting is you might want to change the course of your affairs. Okay, so just to answer this question a little bit though. Okay, so where does one serve the private administrative process via registered mail? The Attorney General's office. They're not going to rebut it. All they're going to suggest is, hey, your line here is too ambiguous. It's frivolous. This is vexatious. Clean this up. And then you'll be like, okay, shit, gotcha. Fix, amend, correct, done. Resend it. They're going to look at it again. No, we still got a problem over here. Your amendment is still short. Fix it again. Fuck, okay. Give it another tweak. Eventually, they're going to say, okay, yes, we can agree to your terms. In good faith and in good conscience. You've given us enough direction. You've given us enough substance. You've given us enough stuff, power to be involved in the trust. They don't control the trust, but they manage it. Now they can actually do things. They can agree to your written agreement. Now a big cha-ching goes on in the background and switches get hit. A whole other mechanism turns on now. Because remember, that security collateralized now shows up specially deposited into the master account from which it came. Imagine this certificate leaves the master account. It's put into the possession of a minor. The minor never comes into truly appreciating what he or she is supposed to do with that certificate. They never redeposit it, put it back from where it came. They're left with this thing. This thing is outstanding for your whole life. And if it's outstanding, nobody can do anything with it. It's at large. It's a gorilla escaped from the zoo, running around making a mess, pooping everywhere, scaring old ladies, whatever. Fix the problem, put the gorilla back in its cage. So yeah, when you do this, it affects the federal level. Absolutely it does, just by its very nature. Again, that LBR, the live birth records, particulars of live birth, whatever you want to call it, the big one, the legal size one, that encompasses provincial jurisdiction and federal in that one instrument. And the isolation of a thing called COVID-19. Would that be a bill in equity? Yeah, when you're coming forward in your dual capacity, cleaned up, now you're standing here in your equitable jurisdiction, that public legislation, public codes do not affect you at all. You got your own public codes. You got your own country. You got your own monetary system if you want it. You are an entire entity, autonomous or not internal to the country that you just left. Remember, this chattel, this security, this trust, this is a resident of the country you're in, but you're not. See the difference? But yeah, if you want to get away from the jabby jab, yeah, definitely a petition, an affidavit supporting that petition, collateralized securities, all sent to the Attorney General and saying, oh, and hey, by the way, I just want to make it abundantly clear for the record that I, me, myself. There's 3. This guy does not participate in public F all, nothing. Go F yourself. That means you go fornicate under contract of the king. Why? Because you've already sworn an oath to do it. You're the one who's fucked, not me. Again, loved ones, it's just this perception of the word. It's like fucked is just like bonded. It's interesting how those two also go together in both realms, oddly enough. When you're bonded, that means you are in a position, there's another word, to serve a certain entity. It's literally prostitution. But now you're no longer the prostitute. You got yourself cleaned up. You're no longer fornicating and having intercourse with these things. Let them do it. Let them administrate it. Again, don't suggest that they are dishonorable, because they're not. We're the ones that had to come forward and clean ourselves up. We're the ones that are dirty. Would it be possible to hear the topic of a husband and wife where they to be in spiritual harmony together, sending paperwork to the same judge at the same time? Yeah, I'm going to suggest, you know what? While we are sending deeds and written expressions to the Attorney General's office, I'm going to suggest this is a beautiful time to insert a marriage situation. Do it right here. This is kind of like, because you're declaring this marriage to be trust property, slam into your jar, into your bucket. Now that your public marriage is trust property, it's actually not public anymore. It's not going to get converted into something else. Aha. Now the state's no longer involved in your marriage, because the state's involved in your trust only to protect it through the Attorney General's office. It's not internal, so to speak, anymore. It can't come in and bring its public policy into your private trust and start fucking things up. No, not allowed. That's why your trusts are not registered. The registered owner of the trust is registered, but not the trust. Who's the registered owner? The state. Whoever's name is at the top of this thing. There. That's the registered owner right there. Now, an agent of this thing, probably the Attorney General or a commissioner, is going to go now make application to land titles and get their expressed interest in this thing registered, recorded, filed. Yeah, so back to the marriage thing. I'm going to suggest this is probably the easiest way to do it. Again, develop your deed, your deed of marriage in trust. Do you want that to be revocable or irrevocable? Do you love this one enough to be, now you're going to be bonded for the rest of your life? Maybe this marriage is going to have a clause in it where every 7 years, the parties to this marriage revisit it. And now they either sign on, continuing it, or this thing defeats itself and goes boom, and the marriage just automatically dissolves itself. Yeah, you can do that if you want. Again, every 7 years, the Jubilee is supposed to absolve us of any debt, because technically, when you enter into a marriage agreement, you're indebted spiritually, emotionally, through love to the other party. I owe you a debt of fidelity, see? And you owe me. But let's agree to the fact that, hey, every 7 years, fuck, if you want to do it every year, whatever. Again, we can create all these variables to serve the larger purpose here. But again, defeating the public marriage by coming forward and expressing all this stuff. Again, this is going to be some dynamite stuff. Anyway, I guess the vibe I'm getting here at this point is, okay, Darren, can you create us a version of what a deed of a trust in marriage looks like? Yeah, probably. I can probably get on that somewhat soon here. Now, who is the entity that's going to register or record the evidence of your trust in marriage? The trust. Hey, I'm the settlor of this marriage trust, and these are the parties to the marriage, and here's all the assets, and here's all the it's all listed. It's all in here. So now, as a settlor, you can go record this event at the Vital People's Office. Births, deaths, and marriages. Okay, so here, this I'm just thinking of this now. Okay, so now, Darren, could there be co-settlers to the trust? I'm gonna say, I'm gonna say that's an interesting question. Probably, if both parties have the exact same interests at the exact same time for the exact same intent, they're both settlers. And it's only a marriage or partnership of some type of an arrangement where this can be done. Otherwise, I'm going to suggest let the man settle this, because it's almost like the man is to have and to hold. The man, for some reason, is the head of the household on the equity side. That's how it was. If we wish to change that moving forward, we can, but let the man settle it. And then within the terms and conditions of the settlement, now right here, you can suggest, although the man settled it, the man does not have a stronger position than the wife. The man does not have more power than the wife. The man does not. Or the woman has equal to this trust agreement. But if you want, as a fail-safe mechanism, I'm going to suggest let the man go and settle this thing. Because why? Equity, for some reason, in the past has suggested that a woman has got very little standing in equity. She has to bring everything through her husband or her next friend, who should be a man. It's just the rules. I didn't make them up. So yeah. So again, where do we send the deed of marriage? I'm going to say, yeah, to the registrar of marriages and deeds and deaths and stuff at the Vital office. Let them see what it is. So again, so here's Dean and his wife about a year and change ago. They did their own private marriage certificate. Six witnesses all endorsed it. This event happened. They took it. They recorded it. But you know what? I know for a fact, Dean did not express any trust agreement or any trust terms and conditions or any trust related items. He didn't identify this special event as trust property. None of that shit. So I'm going to suggest, has Dean and his wife protected their interests by only creating a private marriage certificate? I'm going to say no. I'm going to say he got the ball started, but he should have gone a step or two or three further. And if you want to do this through a judge, sure. If you want to do it as part of your other trust package that you're setting up with the Attorney General's office, do it there. Do you want to just do it to a registrar? Sure. So there's three options. Whichever you pick. I'm going to suggest you wrap it into your big monster deed that we're developing right now, because you or your spouse's property interests are sort of your business, sort of the trust business. So let's deal with it all right then and there. If you want to extract clause 1.13 out of your big deed, where you're talking about marriages and partnerships, right here is where you can literally take an extract out and attach this to another schedule and say, look, Your Honor, as part of a schedule, or this schedule made as a part of this trust indenture, or we got over here, I'm kind of isolating this particular event and I want to deal with this specially, Your Honor, to make sure that this is all hunky-dory. Again, we literally acquire leave from the public system the moment we start expressing trusts. We technically don't even have to ask or require or motion for leave if we're bringing our trust expression properly. It's kind of built in. You are already exercising your leave by creating the trust. It's kind of already happening. Will you please be more specific about explaining what your exact meaning is behind when you and Dï5 say we must enter the kingdom of heaven alone? I'm going to suggest to get into the kingdom of heaven, you need to do something like this. You got to dispose of your sin. We don't get into the kingdom filthy. We don't get into the kingdom full of sin. We got to get cleaned up. This is why when Christ suggested, you don't get to the Father but through me. The but through me is the cleaning process. You got to come to Christ's consciousness clean. Once you do that, now you're allowed in. By you and your certificate being allowed in, that's you. Where do your children and your spouse and your grandparents and your neighbor and people you don't even, where do they fit in? They don't. This is just for you. When you cross the gates, when you got a cherubim on each side, and they are like, I don't want to say extremely powerful, but they're extremely powerful. They're the gatekeepers. You're not walking up to the gate with your son, your daughter, your wife, your dog, your cat, and your RRSPs and your car and your house. That's not how this works. This is meant for just you. Only you enter the garden. Only you have direct control over your sin. How are you going to clean another man or woman's sin for them? Well, I guess Christ was kind of doing it. So if these family members are following in the consciousness that you're laying down, they're going to be right behind you. Don't worry about it. But they're not going in with you. That's only one entity at a time. Check, next, check, next. Your wife may be right behind you with her transaction, and then the children may be right behind your wife with their transactions. Yes, but again, loved ones, each transaction is singular. Every sin is the result of a singular action which caused it. Your wife should not be held accountable for your sin, and vice versa. No, that's your particular doing, your wrongdoing. So we got to deal with our particular personal doings alone. You face the fire, you face the judgment alone. You don't roll into judgment and say, oh, hey, wait a minute, I would like to bring my wife in here. It's not how it works. Don't worry, though, when you're all clean, you're all getting in. By default, that's just how this works. Okay, so I think I got that one. Alone. That means you and Father. That's it. Through Christ consciousness somehow here in spirit, you overcame sin, really. You believe and feel, assert, and know you're entitled to stand here right now in judgment. If you want to stand in judgment and not do any of this stuff, have fun, because it's going to get really warm, really quick, and you're going to feel like you're drowning. Heart, mind, chakras, going on the processes. This is why the 70% is important. If you roll in to the gate with 30%, haha, look, gatekeepers, I perfected my interest. But I still intend to do hookers and blow tonight. Really? The gatekeepers might say, well, that's a little bit dirty. We're not sure if we're going to let you in today. Versus the man or woman that came in with the cleanliness and suggested, hey, you know what? I wish to allocate or apportion an amount of my trust estate to help the prostitutes. There, that's a better way of saying it. By doing the prostitutes, I wish to do them well. Here, I'm going to go find a group of prostitutes and try to bring them to the light. I'm going to go fishing. Oh, that's a fantastic idea, Darren. Yeah, of course you can come in the kingdom. Again, charitably. When you're acting charitable, this is huge. Always be present of this. That feeling should never be very far from your mind and your heart. When you feel yourself getting pissed off at something and something triggered you, you've just been disposed of your peace, your peaceful place in the garden. Something just came along and knocked you out. Now you're over there confused. You're thinking, what the fuck just happened? Why did I just get triggered? Why am I so full of rage? Why do I want to punch you in the face all of a sudden? Well, you know what? You're not going to feel like punching someone in the face, regardless of what they just did to you, when you're at peace and you have charity in your state of being all the time, perpetually, continuously. You're going to resort from violence. We don't need violence anymore. And as a matter of fact, I was speaking to Jody this morning about, okay, I know I mentioned alpha and beta stuff a lot. I'm going to do another quick segment on that up and coming here as to what that actually really means. And it's not just some big guy. That's not what alpha means. It's not. Another segment though. So, okay, I think we got the entering into the kingdom. I think is this the last one? Hang on. This is the last question. We're going to make this one extra special. Oh, apparently we got some more coming. Okay. Would it be possible to have a more clear explanation about what a statement you made in a very recent video you posted called Stones Alchemized, where you stated that going through a judge was unneeded and we could all go through the Attorney General only? I've certainly touched on that one today. Yeah, okay, so Peter, we're looking at this. The conflict happens at the moment we identify as that thing. Now, because that is such a heinous thing we did, normally I would suggest, yeah, we got to go to a judge to get that mistake undone. What I'm suggesting is we can say, hey, Attorney General, notice the fraud, error, mistake, or accident I was a part of when I was 16. And as a result of that error, mistake, accident, or fraud, I'm here to set the record straight. I'm here to create a written agreement between myself and the state. I'm no longer deemed an enemy, a belligerent, a lunatic, a rebel, an asshole at war. And I can prove I'm coming with clean hands because of what I'm doing here. Because of what I'm doing here and the package, the resulting package, the deed, the affidavit, the claim, the disposition of interests, all the shit we write on the birth certificate, all this stuff in a nifty little package. Here you go, Attorney General. You now are in possession of the person legally. I'm kind of technically enjoying the person beneficially over there, sitting on the beach. We don't need to go to a judge. You can. Don't get me wrong. Yes, you can. All the judge is going to do is bring the Attorney General in and say, okay, Peter's got a dispute with you, Mr. Attorney General. What do you say? Attorney General says, well, I didn't get any written agreement from Peter. I didn't get any transaction from Peter. Peter didn't give anything to me that I can help Peter. So, Your Honor, you know what? Actually, we don't know why we're here today. And the judge says, well, Peter, what's your intent? What are you trying to do here? And Peter says, well, all I know, Your Honor, is no trust can fail for want of trustee. Judge says, okay. Attorney General, can you help us out here? No, Your Honor, because we're still not in the possession of any particulars that would give rise to such a claim that Peter's making. Judge now looks at Peter and says, okay, well, Peter, is there anything you can provide the court today? Or is there anything you can do to help us out here? Because we've got kind of we're not really sure what you want us to do. And Peter says, well, Your Honor, I'm trying to create a trust. The judge says, okay. And I know I'm not supposed to act in person. Judge says, okay. And then Peter says, and I don't really know what to do after that. And the judge says, well, I suggest you frame your claim a little bit more concisely, a little bit more precisely, so that the court is warranted on acting in favor of the petitioner. Peter goes, fuck. Okay, well, I guess I'll have to come back, Your Honor. And the judge says, okay, please do. This case dismissed. What I'm suggesting here, Peter, is that you can create a whole window of opportunity by getting rid of the dispute, getting rid of the conflict by providing this written agreement. It's going to be a security agreement and an administrative agreement combined. That's what this is. Now, again, as I posted here the other day, part of one of the security/administrative agreements and part of the deed that I'm working on, there's one portion there where it's incredibly technical. There's words and there's things bouncing back and forth where even I'm like, oh my God, it's crazy technical. I'm going to give that one paragraph out publicly so that we just kind of use that as a center point and then build from it. Why? Because it's good. It's hardcore legal tech stuff that the banks certainly understand. The lawyers know what the hell it is you're talking about. So I'm just saying, let's use that as a nexus point where we build from it. And then we start smashing doctrine all into it and create this trust properly. When you create the trust properly, you can do it through direct communication with the Attorney General's office, acting as the administrator of your trust, the trustee. You got a settlor, Peter. You got an duly appointed trustee, the Attorney General's office. And now you also have a specified and direct beneficiary, Peter, acting in a different capacity. You know, the guy sitting on the beach. 3 parties are present. This is what gets the trust effectuated or having effect. Now, again, as I mentioned earlier, if the Attorney General's office has any problem with any of the wording in your document, they're going to work with you. Again, stop looking at these people like they're the enemy, because they're not. Once you provide a pretty solid document to them, they're going to work with you. They're going to respond. They're going to say, okay, here, just fix and tweak this, tweak that. And if you say, no, I refuse, I'm tired of playing this fucking game. I'm not doing any of this shit no more. We're going to take it exactly the way it is, and we're going to go to a judge to have a judge interpret what we're trying to do. Yeah, you could do all that. Or you could just say, well, okay, Attorney General, this is what I think you're trying to say, and I believe this will satisfy your requirement. Thank you. Please let me know if it doesn't. Guess what? They will let you know if it doesn't. They will go back and forth, back and forth, back and forth as many times as you have to. Because ultimately here, loved ones, we want to avoid going to court. We didn't go to court to create this problem, so I'm going to strongly suggest that we don't have to go to court to finish it. I laid it out to the world a year ago. Yeah, we're going to have to go to court to put you into a specific frame of mind where you were going to overcome the fear of having to go to court. As soon as you overcome the fear, Divergence, we can work with you better. When you're absent the fear, you will go get the job done. So now that you're at an elevated position of confidence, and now that you really know what the hell is going on, because you've been preparing yourself for the last year to go to court, now that you've got some pretty sturdy legs, now that you've got a foundation, now that your wings are spreading, now take that confidence and go to the Attorney General and say, let's avoid the court process. Let's just deal with this privately. What do you say, Attorney General? Hey, Attorney General, duly appointed to act for the trust privately. The Attorney General is going to start to play ball. Yes, they act in honor. Of course they do. The Crown, Her Majesty the Queen, and right of whatever the hell province or state, cannot be seen as acting in dishonor. Otherwise, the entire process falls apart. We're the negligent party here that created a whole shit show, not them. Yeah, they gave us the ability to do it, but it was only our lack of knowledge that actually got it happening or rolling. So, yeah, I'm going to suggest, again, if you're all geared up now and you're super confident, you want to go to court and you want to bring the Attorney General in and have the court verify or divest the legal interest in you and vest it now in the Attorney General, yeah, you still can go do all that. Just depends on where you're at. If you have the wherewithal and the confidence to do it, go for it. Again, they want us to be able to manage our affairs. When you have the ability to bring a court action, whether it's singularly or at all, and others, on behalf of a class of petitioners, if you feel like you want to spearhead a class action all done up in equity where your entire family's a part of it, some of your friends, some of your loved ones, maybe you want to bring your preacher in on this one and teach him a thing or two. So that now when he or she rolls into church on Sunday, you want to see a firecracker under that precast, look how positive and look how happy that individual is going to be. I know I've done this for a minister. I saw what happened, and I heard the feedback from this man's congregation when he got a little bit of download of equity, and when he went in and started to roll that out, it had an incredible effect. Kind of like the meditations for the children here, the youngsters. Look what that's doing. We just got to throw the stone into the pond to get the ripple effect. Eventually, these ripples turn into waves. Again, this is the whole point of what we're trying to do here. So again, loved ones, go to court if you're so inclined. It's a fantastic experience. All you're going to do is gain confidence and strength from it. By the time that actually happens, and right now, if you have a week between now and your court date, trust me, loved ones, you can get a lot of stuff done. Because I'll keep laying this stuff out for everybody. I think other than that, I think we can roll into some other questions now.
Okay, so we're going to start right where the chat started, right after the live from last night, and we're going to get all caught up. Somehow you ripped through 70 questions. Very good. So we got a question here from Carol who said, I totally want to do a birth certificate with the bank now regarding a loan. I will re-listen to the Q&A from tonight to determine if I understand the pieces to do. I will share and look forward to any tips and fine tuning. But is the birth certificate like a check? I want to make sure I put the correct wording so that they can set up a special account for set off.
Yeah, I'm going to suggest it absolutely is a type of a check. It's a negotiable instrument. It meets all the requirements of such. If you want to go check the Securities Exchange Act, and you want to check the Securities Transfer Act, all things securities, these things absolutely qualify. Why? Because the entire freaking commercial system is built on these. So absolutely they qualify. Now, if you want to call it a promissory note, I don't want to call this a promissory note because I'm not making any promises. I'm dealing in facts. I don't promise that in 30 days, I'm going to lodge this thing with the Attorney General or the bank. I'm doing it right now. So why make a promise? The only promise would be that they promise to go record this thing. They promise to set up the set-off account. They promise to act in good faith. Those would be the promises that are a result that you can cash in on. When again, loved ones, when these servants have sworn an oath to serve, it's taken for granted that they're going to do it in good faith. Simple. So yeah, if you in layman's terms, if you want to call this a blank check, yeah, absolutely. So now how do you endorse it properly, and who's it made payable to, and things of all this nature? Again, you gotta fulfill the rest of the requirements of this check. Now, this document here that I've put forward, this has to do with Jody, and this has got a bunch of personal stuff on it. Now, because this is going to be ripped off on YouTube, I probably won't show that document again. If you want to, pause this video and blow that thing up and try to read it, go ahead. But don't worry, in the next day or three, I'm just going to do a little redacting on this so that I don't divulge all of Jody's personal information. And then I'm just going to post this again, probably on the Divergence live chat, or I could maybe do a 20-minute Zoom explaining it all out, whatever. But yeah, so this segment, this Zoom meeting is definitely going to fill in a bunch of, this was Carol's question. This will, Carol, help fill in a whole bunch of blank spots for you. But yeah, don't worry, there's going to be another better version of this coming in the next day or three anyway. So,
and Curtis added on to this, saying that I was thinking about the concept regarding the birth certificate and it being a receipt given to us, identifying we have a securities account in place. The numbers and name on this receipt prove our account, our security. So the birth certificate could be used at the teller as a check. Could we open an account based on the birth certificate information?
Absolutely. We open a public, non-individual account with the birth certificate, right? When you open your bank account, they wanted to see some proof of ID, and a lot of times they wanted to see your birth certificate. So when they're looking at your birth certificate, they're like, oh, look, there's no special endorsement on it. Look, there's no assignment. Look, there's no acceptance. Oh, they've abandoned it. Okay, we'll open up the public account for them. Boom. See, we've already used this instrument to set up the shit account for us. So can we use it to go set up the good one? Yeah, of course. Which is why they can instantly kind of just flip the switch in the background and everything converts. Why? Because they've already got a copy of your unperfected birth certificate. They've already got one. Probably your driver's license, maybe a passport, or whatever bullshit you use to get the account going. So now, rather than depositing debt into your account, okay, so just think about this, loved one. You got a public account and you use debt to open the account, and then you show up as the debtor. You just see how this has a dirty feel to it already. Where's this account heading? Down a shitty, slippery slope. That's it. Show up with your equities, show up with your entitlements. And again, the security entitlement. Who's entitled? Who's the security entitlement holder after you do this? The bank. They've got the entitlement. They're the holder. They've got the security. They're the debtor, or acting as an agent for the debtor. They're the transmitting utility. They're the clearinghouse that literally has the direct access to Treasury. So again, you can run all this through a chartered bank if you like, or if you're really savvy, you can set this up through the Attorney General's office and go start your own bank. Literally, loved ones, take your security, collateralize. You can literally go set up your own trust corporation to conduct public affairs. where you can take other trust deposits and you can be the negotiator. You could be the clearinghouse. You can be a bank if you want. But that's a big undertaking. Does everybody want to do that? Versus just go and depositing your instrument at a bank that's already existing, let them reap huge profits. You're going to get the beneficial use and enjoyment out of all the property you could ever imagine. See how both parties are happy. The bank's going to love you. Oh yeah, absolutely. Did I hit that one good enough? What else was there?
How do you do that with the first certificate?
Yeah, okay, so like I'm saying, this is how you negotiate that certificate. Wrap it up in an agreement. And I'm just going to see if I can here, I'm just going to read one paragraph off of this, okay? Whereas RBC, a royal bank, being in direct receipt thereof. That's what it was, because we were talking about receipts. Yes, this thing is a receipt. This is a receipt to title. You can do stuff with this receipt. You can literally submit it to be reimbursed, just like you do for taxes when you buy a car and you're trying to write it off through some kind of corporate expenditure, how you needed the Ferrari as advertising for your company, and you're entitled to certain write-offs, right? A portion. Yeah, you can do all this here with the same process. Okay, I'll start this again. Whereas RBC Royal Bank, being in direct receipt thereof, and notice of said declaration with attached trust indenture and security agreement, the agreement in brackets, in a separate instrument. You just told them it's not here. You're just referring to it. Dated, whatever the date was, and duly executed therein, and subsequently being duly delivered to RBC Royal Bank at its principal address for service, or the address believed by the settler to be an effective mode for acceptance of the nature and scope of the intent of the transaction. And another paragraph. So again, I'll do up an exploded version of this. We'll be talking about this in great detail because, again, can it really be this simple? Especially depositing this thing back into the account where it was originally created. Did you just see a bunch of light bulbs go off there? You should have. If a security goes out or a certificate goes out and then you put some other species in, like debt, you see how there's a conflict going on here? Grab that thing, perfect it, and slam it right back into the account from which it came. Guess what happens?
We have actually some fantastic questions from a character called Laughing Fun online. Sadly, we cannot take your questions. Darren did make it very clear. We do not deal with fictional characters moving forward. We need your first real name.
Yeah, whether they're laughing or serious.
Okay, moving forward. Next question comes from Scott. I think CRA is actually our friend. They are both the bookkeepers for both sides of this world, public and private. Is that true?
Absolutely. When you do the process we're talking about, consider the degree to which they haunt us with the phone calls and the threatening letters and all, we're going to throw your ass in jail. So when you take that degree of haunting, what's the direct opposite of that? Yeah, they're capable of that too. Again, they only operate based on what we put in. If you want to put in garbage and shit intent, you're going to get that out.
Next question comes from Barry, who says, can you please clarify the role and function of the relator? Now, I know you touched on this.
Oh, yeah.
But he said, I see in Black's law, it's a male, unlike a relatrix, who is a female relator, an informer.
That'd be a relatrix.
Relatrix.
So you got a masculine and a feminine.
So would this be the AG acting as trustee to relate a writ or petition on behalf of a trust? And is there a relatee as well?
No, you're the relator to this thing, the certificate. I have specified relations to this. As the relator, I'm not it. And allow me to define what the relationship is. Well, on such and such a date, I became aware of a trust, and I became aware of a liability, and I became aware of all these parties that are involved, and I became aware. No, the Attorney General does not act as the relator here. That's for us. That's us acting ex rel. Ex rel is ex relation. As in, I'm related to this thing, but I'm not the thing. The thing is liable, not me. That's like, if your wife is liable, okay, I shouldn't use that. If your friend has a car loan and is falling behind on his or her payments, can the bank now come to you and say, yeah, but you're a friend of that person, so we're going to come to you for the debt now? No, you have no direct relation to that transaction. See? So being in relation to it simply states or stipulates that you're not the it. I'm a relative. You'd almost say I'm next of kin, because I know that is on the birth certificate application. State your relationship to the certificate. You have one box that says it's for me, it's for myself, or there's a next of kin. And then it says, okay, well, please describe your relationship to the certificate. Right there, you might want to say, well, I'm the relator. I've expressed a trust. I've disposed of the interest. And this application is to do the following. Again, you can expand on that from there.
Okay, and last question comes in from Carol. What should we use to attach the coin? Now, I told her about clear tape, but is there anything fancy, because she wants to make sure that the document is not damaged?
Yeah, you know what? These plastic certificates, they're pretty indestructible. You can hot glue gun your coin to the certificate. And again, are they going to peel the coin off or not? They may not. They may just leave it on there, especially deposit this financial asset as is. I think in the past, they've peeled the coin off and returned the coin to us because we didn't quite get the process nailed down the way we wanted to. So I'm going to suggest that the consideration and the collateral stay married. It doesn't get divorced. They keep it together. Now, having said that, if you go do this and they do send your coin back to you, don't come and say, well, Darren, you said. It's all I'm suggesting is they could do one or the other. They're not supposed to hold the consideration. I've come to experience this in the past. But at the same time, okay, why? Well, they only use the consideration. They only use the value to transfer the title. Once the title's transferred, they can literally send the consideration back because that's valuable. They don't really, once the value is attached, it's attached in spirit. It's literally attached proverbially. They can literally take the physical consideration off now and give it back. So they may do one or the other. Don't worry. If they do one or the other, it's still going to all boil out to be what we want it to be anyway. Do we want to be using a gold coin? Yeah, I'm thinking about attaching one on my next volley that I'm doing. There is some, I think it's in scripture, where it says if a man, it says something about like a man is considered insolvent or a man is considered a pauper if he does not have at least 21 pieces of silver. So am I suggesting we need to attach 21 silver coins to this document? No, one gets it done. But again, it depends on what level you want to take your onion to. I know our friend in the United States here that I keep referring to, I know some of his students literally attached 21 pieces of silver to a particular document where they were trying to acquire an interest in particular land. But again, is that necessary? I'm going to probably say no. You can probably get it done with the one coin. And again, this is where when you start dealing with the Attorney General's office and you're like, oh, and by the way, Attorney General, the trust is found wanting of an actual principal trust residence. The trust is thinking this property. The trust is thinking it would like to have this property as its principal trust residence. Put it through. If you find a listed property that's for sale, a trust can now acquire its use because it's listed. Listed is an important word in admiralty and equity. When a property is listed, again, what does listed mean? It means it's listed, it's on its side. When a boat or a ship lists, Google that one. It's literally changed its position. It's like something else is going on with the boat. If it's changed its position, it probably has changed its direction. And if it's changed its direction, its course might be altered. And if it's on an alternate course now, it might have a new destination. Maybe that port of entry is better suited for the trusts than you coming forward and say, yeah, I want to be the debtor to this ship. Wrong answer. So I know that was a little bit sideways there, that last little bit, but again, it's just how these things all start to interconnect and deal with itself. Again, springing and shifting interests. Your Honor, my equitable interest sprung as a result from this. use the word springing and shifting. If you want to do a little bit of Black's Law, Googling and searching and see, okay, where and when do we want to use shifting and springing? If you can't really find anything, again, I'll fire some of the stuff I've come across in another presentation or Zoom here coming to you at a theater real soon. IMAX is where we should be doing all this stuff. Okay, I think that's pretty much got that. Anything else?
I think we're good. So yeah, we'll send this over for Kim to do her magic, and we'll get this online as soon as possible.
Okay, loved ones, peace till the next one. And probably let's just tentatively book, I don't know, maybe next Monday to do this all again. Keep the questions coming. And again, look at the quality of the questions that are coming from you now. See, that's the proof that this stuff is starting to sink in. That's the proof that your ability to manage your own affairs is working. This is why we got to throw you in the grinder to get you better. Yeah, it hurts when you're going through the grinder. It's a big undertaking. Yeah, I know. But to absolve yourself of sin, we want to make sure that once you clean yourself up, you don't just revert back to the same shitty, sinful ways. And you won't when you have all this knowledge, wisdom, and that we talk about. Okay, loved ones, lawnmowers aside, we will talk to you very shortly.